Welcome back. The session we are about to begin is going to be an essential watch. Experts have a way to influence the outcomes of construction disputes that's unparalleled and to an extent unexplored too. Be ready for a deep dive into the relevance and role of experts in determination of construction disputes. Our session is exclusively brought to you by our platinum sponsors FTI Consulting. FTI Consulting is a leading global provider of project advisory, construction claim analysis, and expert witness services for some of the world's most complex, high profile projects. FTI's multilingual construction experts draw on diverse backgrounds and in depth industry experience to provide a multidisciplinary approach to help prevent, manage, and resolve construction issues. We have with us Mr. Graham McNeill, Senior Managing Director and Global Leader of Construction Solution at FTI Consulting. Mr. Neil will be our moderator for this session. I welcome Mr. Neil to take over the session now.
Thank you, and thank you. Good afternoon, ladies and gentlemen, and welcome to Session 6 of the SCL India Conference, where we'll be exploring the relevance and role of experts in construction disputes. So I'm joined today by an esteemed panel of both lawyers and experts, who I'm delighted to now introduce. I'll first bring in Philip Boulding, QC, and introduce Philip. Philip was called to the bar of England and Wales in 1979 and has been a member of Keating Chambers since 1980. He's now based in Asia and specialises in the fields of construction, engineering, technology law, and related professional negligence work. His practice comprises primarily international arbitration work, and his clients include local authorities, government departments, major national and international construction and engineering companies, energy and utilities companies, and developers. Philip is regularly appointed as a QC, arbitrator, and adjudicator, and has worked globally across multiple jurisdictions. He's praised as a hard-working silk and powerful cross-examiner who is always there when you need him, quick to respond, very thorough, and a brilliant team member. Next to the panel, I'll introduce Glenn Haley. Glenn is a partner with BCLP and brings over 35 years' experience in all aspects of major projects, infrastructure, and construction and engineering sectors in both contentious and non-contentious matters. He's also represented government and semi-government bodies in the implementation of numerous large-scale infrastructure developments, including airports, rail projects, bridges, roads, tunnels, power generation projects, and commercial structures. Glenn's considered one of Hong Kong's most preeminent disputes resolution practitioners and is recognised by Who's Who of construction lawyers, Asia Pacific Legal 500, Chambers Asia, and Asia Law. Glenn has lived and worked in Hong Kong for over 30 years, handling matters through Asia Pacific region, and is actually also a past chairman of the SCL Hong Kong branch. Next to the panel is Kenneth Beale. Ken is an international arbitration partner at King & Spalding and splits his time between their Washington and London offices. He's advised clients for more than 15 years in numerous bet the company, international commercial and investor state arbitrations throughout the world and frequently handles matters involving Indian clients. Ken is described by Ranking Services as being one of the best in the field, who is very experienced in handling large cases and is a standout for his insightful and great oral arguments. He represents clients in enforcement proceedings and in litigation in support of arbitration proceedings. Ken has actually lived in India and teaches international arbitration law, lecturing at the National University of Juridical Science in India. Next, we welcome Kartikey Mahajan. Kartikey is a counsel in the disputes practice of Shardul, Amarchand, Mangaldas and Co. And he's actually triple qualified, being allowed to practice in England and Wales, New York, and of course, India. Kartikey serves as the Joint Secretary of the Society of Construction Law's India chapter. His practice focuses on international arbitration matters, complex multi-jurisdictional litigation, and white-collar investigations. Kartikey represents clients in ad hoc and institutional arbitrations seated in both common law and civil jurisdictions around the world. He's represented contractors and employers in numerous construction arbitrations in relation to projects in India, the Middle East, Europe, and Southeast Asia, and regularly advises clients in cross-border disputes with an Indian element. Next to the panel, we have a colleague of mine, Karthik Balisagar. Karthik is a Senior Managing Director and leads FTI's consulting, economic and financial practice in India. Karthik has 16 years experience in valuation and transaction consulting and has worked in India, Singapore, and the UK. He specialises in valuation and damages issues in the context of international arbitration and litigation, and he's been appointed as an expert witness in numerous litigations and arbitration matters. Karthik has prepared expert reports for submissions to Singapore, UK, Dutch, and EU courts, as well as in arbitrations under multiple rules and jurisdictions. He's currently a member of the International Valuation Standards Council, where he assists the board in setting and harmonising international valuation standards. And finally, if I may, a little about myself. My name is Graham McNeill, and as you'll have guessed, I'll be moderating today's session. I'm the global head of FTI's Consulting's Construction Solutions practice, and I'm based in Hong Kong, but I work internationally as a quantum expert witness. I've been appointed as a quantum expert on over 40 occasions and given evidence and been cross-examined in multiple jurisdictions across Asia Pacific and EMEA. And like Glenn, I'm also the past chairman of the SCL Hong Kong branch, and as such, I'm delighted to host and support the SCL India chapter. As mentioned earlier, we've been tasked with exploring the relevance and roles of experts in construction disputes. So we've opted to address today's panel discussion in a Q&A format, where we'll consider the use of experts in arbitration and litigation proceedings from both a local and international perspective. So with that, I suggest we jump right in, and I'll direct the first question, if I may, to Phil. So Phil, given that we've been asked to cover the full spectrum of expert activity, I thought perhaps the most obvious starting point would be to get your thoughts on who and what precisely is an expert and why, in fact, we would ever need one in an arbitration.
Well, thank you very much, Graham, and thank you for that introduction and for inviting me to speak today. That's a very good jumping off point. Who is qualified as an expert? Well, the test is whether a particular person's expertise would be helpful to the court or the arbitrator in arriving at its decision on one or more of the issues to be resolved. And as one would expect, that is potentially wide in terms of the range of matters which expert evidence can be given on, and would include, for example, technical matters, scientific matters, medical issues, the law, and the like. Now, the realization that expert evidence can assist a tribunal reach a correct decision on a particular issue is of some antiquity, notwithstanding the fact that expert witnesses are now, of course, accepted as part and parcel of both criminal and indeed civil trials. But in terms of its antiquity as a profession, or in terms of its assistance to tribunals, the use of expert evidence and its admissibility has developed over the last 250 years. Yes, 250 years, when the concept of allowing expert evidence to give expert witnesses to give opinion evidence on the facts of other witnesses was allowed by Lord Mansfield in the English case of Folkes versus Chad in 1782. That case is known as the Wells Harbour case. And this case was heard in 1782, many years ago. And the situation was that different experts had been heard in terms of whether the position of an artificial embankment had caused the silting up of a harbour at Wells by the Sea, a town in Norfolk, England and thus constituted a nuisance. And most of the experts had seen the harbour, but not the famous scientist Smeaton, who was one of the most famous scientists of the day. And there'd been an objection to Mr. Smeaton giving evidence as to why the harbour was silting up. And it was decided that his evidence was thus initially inadmissible. Notwithstanding, there was an appeal, and Lord Mansfield described the evidence of, and I quote, men of science as being admissible before the court. Now, since that time, the use of expert witnesses and the admissibility of their evidence, their science, has developed very substantially. But in my view, it is worth reminding ourselves of what Lord Mansfield said all those years ago. And I trust I'll be forgiven for quoting from his judgment. He said, "It's objected that Mr. Smeaton is going to speak not to facts, but to opinion. I cannot believe that where the question is whether a defect arises from natural or artificial cause, the opinions of men of science are not to be received. The cause of the decay of the harbour is also a matter of science, and still more so, whether the removal of the bank can be beneficial. Of this, men such as Mr. Smeaton alone can judge. Therefore, we are of the opinion that his judgment, formed on the facts, was very proper evidence." And since that time, the speech, the judgment of Lord Mansfield has been approved in various English cases. For example, the case of R versus Turner in 1965. Now, as to the sort of expert evidence that will be received by a tribunal, I've touched upon that already, but I think it's worthwhile quoting from a fairly recent judgment of Lord Justice Bingham in the English Court of Appeal in a case called R versus Robb. That was in 1991. And he stated as follows: "The old academically established sciences such as medicine, geology, or metallurgy and established professions present no problem. The field will be regarded as one in which expertise may exist, and any qualified member will be accepted without question as an expert. Expert opinions may be given of the quality of commodities or the literary, artistic, scientific, or other merit of works alleged to be obscene. Yet while receiving this evidence, the courts would not accept the evidence of an astrologer, soothsayer, a witch doctor, or an amateur psychologist, and might hesitate to receive evidence of attributed authorship on stylometric analysis." So a useful indication there from the English Court of Appeal some 20, 30 years ago. And in terms of what they do, I've touched upon this already, an expert or experts are necessary to assist the tribunal in reaching a decision on disputed issues, e.g. technical issues, which importantly, I emphasize, the tribunal has not been trained to deal with and is thus not qualified to deal with. And to give a very simple example, for example, why a newly erected building is starting to collapse. One would expect to have engineering expertise before the tribunal, before the court, to assist the judge or the arbitrator come to a decision. So I hope by way of an introduction, Graham, that's useful and can kick us off so far as the rest of our discussion this morning is concerned.
Yeah. Excellent, Phil. Thank you. If I could pass on to Glenn now. Glenn, having understood who qualifies as an expert from Phil, perhaps you could explain about the different types of expert that might be considered in construction disputes.
Thank you, Graham. And thank you, Phil. I've been in a number of large arbitrations with both Phil and Graham. As Phil says, it comes down really to what areas of expertise, and they need to be expertise, are likely to assist the tribunal in reaching its decision in the case in question. But the common types of expertise that we see in construction cases will often have a planning expert. Some people call them programming experts that look at issues of time. Why has there been delay to the works? The cause of them, etc. Quantum, so even though you'll have all the underlying records about money spent, and it's not the expert's job to say who is liable to pay what, but to help find your way through the masses of accounting and financial documentation that you find on construction cases. We have quantum experts help us with that, because if you were going to have normal evidence of having to put every invoice, every receipt in front of the tribunal, you could be there for many days, many weeks, even many months, and the costs would blow out of proportion. So we find that quantum experts can be extremely useful and, in fact, almost essential in cases. Then on to what Phil spoke about being technical, and he gave the example of the engineering expert, and we usually need those as well. Of course, there's no list of them. It depends on what's in issue in the particular case. Some arbitrations I've been on with Phil, it's been about the construction of large cut and cover sections of an infrastructure project, where to carry out the cut and cover sections, large sections of diaphragm walls were needed. So we needed experts about how to build diaphragm walls. We also needed experts about the government approval process, what would be regarded as defective, what would be acceptable workmanship. And another big arbitration Phil and I had was on a toll road in another Southeast Asian country. And a lot of the expert evidence there were from asphalt experts who knew about asphalt. All of us have driven over asphalt, but the complex process of designing an asphalt mix, laying it, what can go wrong, how do you fix problems that go wrong, you need experts about that. So really it depends on the type of case, but there's a large range of expertise, and with the complexity of some of the construction arbitrations in which we get involved, it isn't, is this a case where you want experts, but rather in most cases, how many experts are you going to have? I think it'd be a rare case where you got away with no experts. Maybe it's just about arguments about the legal issues of the construction of the contract, but that would be very rare. So that's the types of expert, or rather the areas of expertise. At this stage, I might just touch upon something that has been something of a running discussion for many years now, and there are quite a few articles out there in the arbitration and the construction publications about, and this isn't just in construction, it's in a lot of other areas of dispute resolution as well. But whether you stick with the traditional way of the parties each appointing their own expert, so you have quantum expert for the claimant, quantum expert for the respondent, and then long cross-examination of each, or should you go for what is favoured by some people of a single expert, and that's either appointed by the parties, or if they can't agree, and that's often the case, then appointed by the tribunal, and so you have one expert. The perceived advantages of the single expert is it saves money, it stops the fear that the experts are going to be hired guns and just argue what they think's in the best interests of their client, or push the areas of their expertise or their opinions as far as they can. And I'm sure we'll come on and talk about that a bit more as this session goes on. Or do you have a single expert where it's appointed jointly, appointed by the tribunal, and so doesn't have that perceived loyalty to the extent that an expert does have that, although they shouldn't, to the party that appointed them, but rather really are just wanting to put forward their single opinion for the benefit of the tribunal. I've been in a lot more arbitrations where it's party appointed experts than single experts. I'm still in the camp that favours the parties having their own experts, but I think that there are ways that you control it by making sure you have agreed lists of issues for the experts, you have protocols up front for the experts to meet early and agree the information they're going to use, the methodologies they're going to use. For example, programming experts, they agree what's going to be the baseline program they'll use for their analysis, which of the various methods of analysing delays will they use, and the list of issues. Also, I have had one case where the expert, being a single expert, really did just get it wrong. And I know people might say, well, Haley, you would say that if he was against you, but both sets of lawyers were of the view that this expert just got it really wrong. And so we both had to cross-examine this expert about how they got it so wrong. And in the end, I don't think that the tribunal had any useful evidence at all on that area of expertise. There's no single right answer. Do you have party appointed or a single expert? Maybe some cases are better attuned to one or the other, but by and large, I'm still in favour of party appointed experts, but with appropriate protocols and hot tubbing maybe at the end, which we'll get onto a bit later. But that's all I wanted to say at the moment, Graham.
Thanks, Glenn. Ken, if I could pass to you now. Glenn's touched on some of the differences between a party-appointed expert and a single joint expert. Could I ask you to share your thoughts on the pros and cons from a legal perspective, and then I think we'll hand over to Karthik and see if he has similar thoughts from a practicing expert perspective. So Ken, over to you, please.
Sure. Thank you, Graham. I think I share Glenn's views on the issue of party appointed versus single joint expert. And I would probably go so far as to speculate that most experienced arbitration practitioners and construction litigators do as well, although there are some exceptions. There's a lot of discussion about a move to single joint experts, and you see courts in some jurisdictions like England after the Wolf reforms moving in that direction. But I think in practice, there's still quite a bit of resistance. Let me, Graham, if it's okay, just say one or two quick words on this issue of party versus joint. And then I'd like to say a word or two about what I think is the underlying issue, which is this issue of trying to avoid hired guns and bias. So, my view on the party appointed versus joint single expert, or rather, I should say, maybe it's not my view, but the view of clients that I often talk to and those in the community that I talk to, is single joint experts can be useful in certain circumstances, particularly if the amount in dispute is relatively small, if the issues are reasonably straightforward, and or if you have sort of issues of expert fact that need to be answered rather than expert opinion that needs to be given. So in those sorts of cases, I think there may be a case for a single joint expert. But I think if you have a very complex, a $100 million or €1 billion dispute with multiple complicated issues, I think first there's a real due process argument, a real due process concern if you don't give the parties the right to bring in their own experts and present the evidence as they see fit, certainly in most international arbitrations. And I think also in terms of helping the tribunal and the fact finders, the process of having party appointed experts does work well with proper constraints. The big argument against it, as Glenn said, is this argument, well, party appointed experts are hired guns and hacks. And I'll just tell you one quick story about this. I think there are real cultural differences about how party appointed experts are thought of. So you can tell from my accent, I'm an American lawyer. I'm sitting in, Washington, D.C. It's 3 a.m. here. And I have grown up and went to law school in a tradition where party appointed experts, of course, they would say that they are objective and they are impartial, but they very often acted as hired guns. And that was what I was used to. And I remember a case that I had as a very young associate at the beginning of my legal career where we were doing an arbitration in Japan. And we hired as an expert a very famous, prominent Japanese professor with lots of gravitas, a very, very sort of older, elderly gentleman. And I explained the case to him. I explained our theory of the case and what we wanted to argue. And he said he would send us his expert report. And I remember getting the report and opening it and thinking, this guy doesn't understand our case because what he wrote isn't terribly helpful to our case. So I immediately responded with an email to him, CCing the lawyer, saying, I don't think you understand our case. Let me explain. Here's what we're trying to argue. And, I've taken the liberty of doing a red line of your expert report. And I've, highlighted the things that I think are wrong. And I've made all sorts of suggestions for you and so on. And I remember that same day getting an irate call from the very senior partner in Tokyo saying, I won't use his exact language at this conference, but what on earth are you doing? First, you're this, brand new lawyer. You've offended this very senior, prominent professor. But secondly, in our tradition, he is independent. He's not a hired gun, and he's given his opinion. He's not going to revise it based on your red line. And, this is very offensive. And that was the first time I realized there was, some cultural difference and nuance in the role of party appointed experts. I think in some jurisdictions in the US as one, you do have experts that are more as advocates. There are all sorts of causes for that, ranging from lawyers who bully them into certain positions to the desire for fees. They want a case or they want repeat business in the future, to just sort of narcissism. Experts want to win. And so I think there are multiple driving factors. And in other traditions and other jurisdictions, there's more of a sense that the role of the expert is to be very independent. Their duty is to the court or to the tribunal. They cannot compromise their integrity. So I throw this out as part of a much bigger discussion on this issue of partisanship, but I think it's behind a bit of the concerns about party versus single joint expert. My personal view is that we're going to have party appointed experts, which is probably good for firms like FTI for quite a while. But I know there is this single joint expert trend. Although, like Glenn, I'm not sure that it's going to catch on with the fire that some would like.
Thank you. So we've heard how different jurisdictions and the role of an expert may be very different and may be considered to be very different in different jurisdictions. That's something I think we will certainly touch on and explore a little bit later in our conversations as well, as we look to try and understand from the legal teams what they consider is required from a good expert witness. We'll come on to that part a little bit later. But if I could turn now to Karthik and ask you as a practicing expert, what are your thoughts on being appointed as a party appointed expert or a single joint expert? If you were offered the choice, which of course we never are, but if you were offered the choice, which one would you personally prefer and why?
Thanks, Graham, and hi everyone. Ken, I hope I never came across to you as a narcissist ever before when you appointed me. But I think I don't have a preference as such, and I can only say this from an English court system point of view. I do see many instances in English courts where a single joint expert is appointed on matters with an intention to lower costs and increase efficiencies, at least in theory. I've also traditionally, although not in all instances, seen that this is a preferred approach where sums in dispute are smaller. Similar to a party-appointed expert, a single joint expert has a duty to assist the court and stay independent. However, there are minor complications on how the single joint expert receives instructions. And I think this is the nub of the issue. The parties are encouraged to provide joint instructions. However, it is often the case that the single joint expert will receive separate instructions. This is, of course, done in a very transparent manner, and the opposing party is in the know. As it is not the duty of the expert to opine on facts, the trouble, this often leads to multiple conclusions rather than a single conclusion. So, I do not have any preference. However, each process has its own merits and demerits, I suppose. This is, again, from an English court system. I've also worked in Latin America, especially Brazil, and this is extremely prevalent in that jurisdiction. And I can relate to what Ken was saying before, that the party-appointed experts generally in that jurisdiction we have seen have taken, extreme views. I don't want to use hired gun, but they have taken extreme views on those matters, and the tribunal ultimately decides to appoint a third expert, who's a tribunal-appointed expert, and FTI generally acts as a tribunal-appointed expert in Brazil. And we come in and assist the tribunal with the questions they have. But the process there has ended up being very inefficient, just because you have to quote unquote hired guns acting for the parties. So that's sort of my experience. I do agree with everything that's been shared by Glenn and Ken for that instance.
Thank you. Kartikey, we've had some explanations now from the panel about who and what an expert is and why they're considered invaluable in certain international construction disputes. Could you perhaps share your own personal experiences of whether there's an awareness among Indian parties and practitioners about the value that an expert brings to a construction arbitration? Is this common practice?
Sure. Thanks, Graham, for that question. I think the answer to that question is a little bit complex, and it can be divided between Indian parties and counsel who are fairly sophisticated and they're aware of the best international practices when it comes to construction disputes and deploying the experts. And the other set being less sophisticated parties who are increasingly getting exposed to what international arbitration when it comes to construction disputes is like. For the first category, I think they are as sophisticated as anyone outside India is. They know the value that an expert brings to the table, to the case. The arbitrators who deal with such cases, they know what an expert can do and how much weight they can add to a particular case. Whereas the other side of the story, which is the less sophisticated parties, I think there the problem becomes complex. And I would say that their understanding of the value add of an expert is fairly limited at this stage. And I'll say that I'll make 4 points in order to substantiate what my experience has told me about these less sophisticated parties. The first point is that a large part of construction claims, you have the government as the employer, you end up bidding out the contract, the contractor comes in, he makes the project, and the dispute enters into a construction arbitration. What I have seen is that because the margins of these infrastructure projects are fairly low, when it comes to the construction disputes, costs are a big factor. And parties, whether be it contractors or employers, they don't want to end up spending a lot of money on a dispute. So what that means practically is that they are not open to the idea of getting someone else involved as an expert and paying for that expert's services. And I think costs are a big factor, but obviously the lack of awareness in terms of the value add that an expert can bring is a huge factor. And what results out of that is that when there is a construction arbitration, most of the complex issues like delay, float, whatever we come across in international construction arbitrations are actually just decided on the basis of correspondence between the parties. So you don't end up seeing a delay expert report in some of these cases, and you just decide on the basis of correspondence as to what the real factor for the delay was, which, for all of us who are quite akin to the international construction arbitrations, is quite a foreign thing. The second point that I'll make is that, I gave an example of delay and how it can be done on the basis of correspondence. When it comes to computation of damages, what I have noticed is that you end up getting damages awarded in a construction arbitration just on the basis of legal principles. So you don't actually end up seeing what the damage would have been by applying the relevant methodologies. What you see as a norm is that generally a 10 to 15% of the contract price is an accepted form of damages in a construction case. So if you end up proving that there is liability, the only thing that you have to show is that 10 to 15% of the contract price is a reasonable estimate, which you can find from some Indian case law, and on the basis of that, the arbitrators end up appointing. Again, it comes across as very foreign to people who end up engaging quantum experts in construction cases to compute the quantum of damages. The third point that I'll make is that it's not only the lawyers, how they are running the case, it's also the clients. Now, for example, the government of India, with all its public sector undertakings, is possibly the largest employer in the country. What they end up doing is they have very good, competent, technically qualified individuals who act as engineers, who act as project managers, etc. But again, because of the cost factor involved, they don't want to end up engaging an outside agency. And I think there is a sense of complacency as well, that we have the best people on board, and in a way we are also the employer, so we are in a better bargaining position, etc. And what they end up doing is they end up putting those technical engineers and project managers as fact witnesses. So they are not testifying as an expert, but they end up putting in a witness statement as to how the project should have been. And they just end up relying on that without engaging a third-party independent expert to verify what the fact witnesses are saying, which, in all likelihood should have been a technical witness, but that's how they perceive their employees to be. The fourth point that I'll end up making is from the side of the tribunal. Now, this is something which I have noticed when, I started dealing with a lot of Indian claims after moving back to India, that the tribunals also don't give that much of difference to an expert's evidence. Again, very unlike the tribunals that you end up seeing in a foreign seated arbitration, say in Singapore or Hong Kong or England. But an Indian seated tribunal, if it's composed of tribunal members who have not been exposed to international arbitrations, they would not see the value add in having a third-party independent expert testifying to a certain aspect in a case. So I think it's the culmination of all these four factors which weigh down the relevance of an expert when it comes to a non-sophisticated client or a non-sophisticated legal counsel or a non-sophisticated tribunal when they are trying to assess the value of expert evidence.
Thank you. Okay, well, it sounds like the use of experts is perhaps less common in some local matters when compared to some larger international disputes. So as such, perhaps there's a number of the SCL delegates that are listening in who may not be familiar with the process of actually appointing an expert. I think it would be helpful if we could walk the delegates through the appointment process from both a legal and an expert perspective, just running through how experts are actually appointed and what's involved and the thought process. So Phil, if I could start with you on the appointment, what is it that you would consider when selecting an expert?
Well, I'm often asked to express a view as to which of a panel of experts we ought to consider appointing. And there are a number of factors, important factors so far as I'm concerned, and you'll not be surprised to hear that there's some overlap between them. But first of all, I would be looking for experience and qualifications in the field in which the expert evidence has got to be given. And in that context, I think it's also highly relevant to point out to the delegates that it is advantageous, to say the least, to have an expert who is still working in his or her profession. Someone who is still on the tools, as we say in the UK, because otherwise, if you end up with a professional expert witness, if I can put it that way, he or she is open to a line of cross-examination to the effect of, okay, well, when did you last actually work on a building site? And sometimes a line of questioning to that effect can establish that they've not been anywhere near a building site. I'm talking about a construction dispute, obviously. They've not been anywhere near a building site for 5-10 years, and that rather undermines what they say about procedures and the like, if those matters are in play. Obviously, a reputation is highly relevant, as is integrity. Integrity is a very, very important point. I want an expert witness who is going to do the job properly, and once he or she has formed a view, it's an honest view that he or she will be prepared to defend to the hilt. I certainly don't want a hired gun. I do not want a hired gun, because that, to use the gun analogy, can very, very often backfire. And that's the last thing I want to be involved in. The person who I advise ought to be appointed is a man or a woman who can and will give unbiased opinions which are related to matters within his or her expertise. And it's also very important, and I'll be interested to hear what Glenn's got to say on this, it's also very important to have an expert who's not too busy and who actually has the time to assist the solicitors, assist the advocates in the preparation of the case. And I think it's also important, and in a sense, I've touched upon this in terms of the hired gun and someone who's truly independent. But I think it's also important to have an expert who is prepared upon mature reflection to change his initial opinion as necessary, as and when the case proceeds and when further information becomes available. Because if for the first time it's established during the course of the hearing that the opinion as set out in the report is not really the opinion that the expert holds, that is a terrible time to try and do any sort of commercial deal on behalf of your client. It's a terrible position to be in. It's far better that the solicitors and the advocates know if there's a change in position, so that hopefully there's still some time to do something about it. So they would be the factors that I would bear in mind and in fact deploy. But I'd be very interested to hear what the rest of the team say, in particular Glenn, because I know he does an awful lot of this.
Thanks, Phil. And I mean, with that, Glenn, could we hand over to you? Anything to add on what Phil has said there?
Yeah, thank you, Graham. Thank you, Phil. Just picking up on a point that Phil made about the expert not being too busy. Obviously, you want to get the best expert for the job, and sometimes they are the busiest of professionals. But if they don't have the time to put into the case, and if they continually miss deadlines, that can either derail the entire arbitration or put all sorts of pressure on other follow-on steps. And so, yes, you must get the best person for the job, and they often are the busiest of professionals. But if they don't have the time to put in, it can cause all sorts of problems. In the same way that if any of us accept appointment as arbitrator for the ICC or a number of the other institutions, they now require the appointees almost to sign in our own blood that we've got the right time, that we have enough time. We have to say what our competing commitments are, and that we will meet the ICC pledge about how long it's going to take us to run this arbitration. Obviously, we have to get cooperation from the parties, but issue our award within the pledge from ICC. So, there's nothing wrong with asking your experts the same thing. But as for the nuts and bolts of briefing your expert, once you've chosen the person with all of the good points that Phil's made, you have to be careful about how you go about the briefing exercise. And just for some of the delegates, what you'll find in some international arbitrations at the moment is that, and it has been for some time now, is that some tribunals will be sympathetic to a request, or even on their own initiative, will want the experts to share what their instructions were, what their engagement is. Now, obviously, there's a tension with privilege there, but there is a certain amount of exploring can go on with some tribunals. So if you are going to have an engagement letter for the expert, keep it fairly anodyne about who's appointing them, why you're appointing them. Hopefully by then, in a well-run arbitration, you may have started to identify what the issues for the experts are, and a good list of issues that's outside the ambit of this particular session, but lists of issues, factual issues, legal issues, expert issues, and mixed ones, so that there's a very clear agenda, and so that experts don't write reports. You have your two diaphragm wall experts, and they're involved in the same case, and they've read the same pleadings, but sometimes their reports can be written as if they're about different projects, and they're looking at different parts of the case and different problems. So have a good list of issues that you want your expert to look into, but just be a little bit careful about the briefing exercise, and have an engagement letter that if push came to shove, and it might not, that you can show to the tribunal. And that's not trying to be in any way sharp practice or hiding things or writing things that aren't true, but you don't have to gush in the appointment letter about, well, I hope the other side doesn't raise these problems, because then, just have the anodyne engagement letter. And then how do you get the expert up to speed? Now, you can swamp them immediately with a lot of information, and you can expose them immediately to your client, who will fill their head with all of the preconceived notions the client has. that might not be the best and the most efficient way to get your expert up to speed. Obviously, you have to be sensible, cost effective, but be careful about swamping the expert. And I'll be very interested to hear what the practicing experts on the panel say about this. Stress to them about keeping within the lane of their expertise, because creep into other areas and being too helpful. And we'll come on later perhaps to some of the pitfalls that perfectly good and perfectly honest experts can sometimes find themselves falling into, or being pushed into making mistakes where they're not hired guns, but sometimes can be pushed to the very extreme of the lane they should be in, and say, well, you've said this, but couldn't you just reword it slightly this way? So stressing to your experts, and also in the appointment letter, reminding them of what their duties are. And there are very well-known duties that an expert owns about being honest, expressing their true opinions, only expressing opinions on areas within their expertise, confirming that if they change their mind, that they'll let the tribunal know. If their opinion is based on any particularly important assumptions, state what those assumptions are. If they've been directed to express a certain opinion, then state that. Sometimes that's what experts have said. Well, look, don't go into reviewing that particular extension of time. We want you to proceed on the basis that we're entitled to an extension of time for that particular event and that it's worth 25 days. Well, you can say that, but just make it clear in your report that that's the basis upon which your report is proceeding, rather than having to have it wheedled out of you in cross-examination when your entire credibility goes out the windows. And then I suppose coming back to what I started with, in a well-run, well-organized arbitration, the lawyers, and that'll be up to Phil, Ken, and I in the legal team, and Kartikey, just about what are the issues in the case. Yeah, the pleadings, which are sometimes hundreds of pages long, and to the non-lawyers, you think designed to hide what the case is really about rather than to make it clear, but then distill it down into sensible, clear lists of issues and listing which are issues of fact, which are issues of law, which are issues for the expert, if they're mixed, and some will be mixed, and then you can identify which of your experts you want to deal with which expert issues, and that's a very good start. That's a lot of spaghetti salad there. So I'll stop now, Graham, before I confuse things anymore.
Thanks, Glenn. I'd like to stay with the legal teams, if I may, and I'll start with Ken, and if Ken could then move on and get some comments from Kartikey as well. That we've heard from Phil and Glenn, their thought process and when appointing an expert, and you've heard the use of words like independence and impartiality. So Ken, you mentioned helpfully at the start that there are some differences depending on which jurisdictions you work in, and perhaps what you're expecting from an expert should the arbitration be seated somewhere in the States is very, very different from what you may consider when selecting an expert in other jurisdictions. So could I ask yourself and Kartikey to debate that, please?
Yeah, and let me say, ultimately, I very strongly subscribe to and agree with what Philip said, which is, I think, there are many lawyers who want to hire hired guns because they think this person will say what I want them to say. And it would be almost malpractice for me not to hire the person that will say what is best for my client's case and will put the biggest number of the damages figure and so on. But that I mean, we've all seen it. As Philip said, exactly, I completely agree. It's a gun that fires backwards in your face. It's just, it almost always doesn't work. You need an expert who has credibility, who is willing to speak truth to power, who is willing to say to the lawyers that appointed him, you have some flaws in your case, you have some issues, and I can't change. I'm going to lose my credibility if I pretend that these things don't exist. And you're going to have a client management issue if you don't tell your clients that these things exist, and then you lose the case. So in terms of handling this, I think I completely agree with what Philip said and with what Glenn has said. I do think that there are cultural differences. I think, those of us who practice sort of internationally and transnationally that do, international arbitration and cross borders, I think we may think a certain way. I think the cultural differences often emerge when you have more local practitioners, the local Texan lawyer in America. And Kartikey can speak about this, but the Indian lawyer in Calcutta who is used to Indian civil court proceedings and not used to larger international proceedings. I think that's when you start to experience, some of these cultural issues in terms of expert relations more. And it's, I think it's our job in some respects to help our clients handle this so that their cultural biases from a certain type of litigation tradition do not lead them to make fundamental errors and mistakes in, arbitral international disputes of the sort that we're talking about.
Maybe I can jump in now, Graham. Just adding to what Ken said, I think I first of all think that Phil, Glenn, and Ken have more or less covered everything that I wanted to say. But I'll just make 4 quick short points from an Indian perspective as to what I keep in mind while appointing experts on my cases now. The first thing I keep in mind is I try and see if the expert, the main expert or its team, has some India projects experience. And the reason why I say that is because, again, it's a very different way of practicing things in India, since the employer is mostly the government or a public sector undertaking. A lot of the correspondence, which is key for a construction case, is actually in the workings of the internal committee notes of such organizations. So someone needs to see that, you can't really ignore it and just get into the technical analysis of things. So if someone is familiar with this large documentation that a government body would have and how to read it, and you end up getting a lot of admissions in them. So I think that is something that I'll look for in an expert team. The second thing I look for is, what Ken was alluding to, that someone should be familiar with the local vagaries of how a particular proceeding is conducted, say it in Calcutta or any other place in India. And again, the reason why I say that is because how a cross-examination is conducted in an Indian seated arbitration can be slightly different and possibly much more aggressive than what you would see in an English seated and a Singapore seated arbitration. I think a lot of Indian advocates take the demolition of witness quite seriously, in which they just become very agitated and, there's all sorts of crosswires being happening in the hearing. So I think as long as an expert knows that this is to be expected, and of course it's our job, like Ken said, to make them aware, I think just having that sort of some experience in your team would help. The third point that I would say is that, again, I mentioned in my first question that I was addressing, that cost is such a huge factor in India. So if there is a lot of back and forth on cost, etc., I think I would urge the clients to think that whether there is actually value in cutting costs and getting the best expert, or actually spending more and getting the best expert. I think I'm on the latter side of things, unless and until there is genuinely a cost pressure that the client cannot do away with. But I find it bizarre when I say that, Indian clients are very cost sensitive, because I've seen it. I was a claimant very recently in an arbitration, and the other side didn't even put forth an expert to counter our findings in our experts report. And I think what that leaves you before an international tribunal with is that you have one side which has come up with an expert who has come up with a very good solid technical report, and from your side there is actually no one to counter it, and the only thing that you're relying on is cross-examination. Again, something for a counsel, you may not be assisted with an expert, you don't have anyone to help you on the technical aspects to understand what a construction project would involve. So again, I think it leaves you in a very weak territory. And the fourth point that I would say is that I think I had a point which I have kind of forgotten in the course of my talk, which would be, yes, I think I think this is a point which is mostly for respondents and possibly for claimant when they're trying to put a rebuttal expert. I think always look at the expert that the other side has put. And I think that's a very common mistake, again, Indian parties end up doing. Sometimes they just end up getting a chartered accountant who's just going to value, the quantum of things in a very simple manner. Whereas if you are the respondent and you've seen that the other side has already put forth a very sophisticated quantum expert, you would want to, rethink your strategy, try and get someone involved who really understands this process and then is able to produce a counter report. So I think that's a point to be kept in mind if you're a respondent or if you're putting a claimant's rebuttal witness.
Thank you. So, Karthik, we've heard now from the legal team about what they consider in their thought process as they look to appoint an expert and consider to how best brief an expert. Again, from an expert's perspective, what's the type of thing, what's your thought process when counsel approach you to see if you're willing to be appointed, and assuming you are appointed, when they give you a brief, what's the kind of things that go through your mind? What are you looking for when being appointed as an expert?
Thanks, Graham. Most of what I wanted to say has been said, broadly speaking, but from an expert standpoint, I think there are three key issues that I would look at. I think the first thing we all check is conflict of interest, Graham. We have a very robust centralized process to ensure that there is no direct conflict or perceived conflicts. Especially large firms like ours work in multiple jurisdictions across multiple areas. So it's very important for the left hand to know what the right hand is doing. So ultimately, as an expert, your role is to be independent and unbiased, and therefore any taint associated with independence can prove to be fatal to your instructing party. So this is very important to us. Two, and often one of the most important point we as expert need to stay true to is this question: does the expert issue lie within my area of expertise? It may often not be a very straight yes and no, or yes or no. Sometimes you may want to rely on other experts' opinions. If so, is such expert already appointed? For example, if it is a classic fraud case where fraud needs to be established to assess the downstream question of quantum, do we have a forensic accountant as an expert, or is the counsel expecting me to assume that the fraud is true? Can this reasonably justifiable position? Maybe yes, maybe no. Can I just rely on instructions? Maybe yes, maybe no. Depends on facts. Again, over-reliance on instruction is optically sort of not ideal and can be open to challenges. So one needs to be careful. Three, I think this is an extremely important point that Philip brought about, is the procedural timetable. Experts like us, and let's be honest, we are too eager to say yes, we have that syndrome. So you may have multiple commitments. It is a cardinal sin to accept any instruction when you know you will struggle to deliver. This could be due to counsel approaching you in the 11th hour, or just because you have other live engagements going on. A simple answer is to say no or direct the party to another expert in your firm. And I think we should all engage in such best practice. Another important point I'd like to mention here is, and I think Kartikey kind of dwelled on it, we need to differentiate expertise that Philip spoke about with experience. So you might get an expert from that field, working on the tools from the industry, but may lack experience of testifying as an expert witness. And we have seen this many times. They falter because they're not used to adversarial style of cross-examination, perhaps, or how clearly an expert report has to be written, because often there could be professors of a certain subject, and it may be a complicated subject, and the way you need to express that in simple terms to a judge or a tribunal is very different than than it's explained in a textbook. So these things need to be considered. So experience matters a lot in this field, and it needs to be an informed decision by the counsel team when they hire an expert. The other things that, I'll just be brief, is it's very important to see what sort of supporting team an expert has. And this point was made by Kartikey. Do they have an experienced supporting team? Do they have expertise in certain areas, whether it's a sector or any functional areas? And again, geographical presence. Do they have certain geographical presence? That is an added advantage. So that is something one would look at. The last point that I have come across is when experts are being appointed is reference checks. So I think it is generally a good practice for lawyers to do reference checks on experts, and I have been asked to provide some reference checks. This is obviously done in in an informal setting, not a very formal setting, but it's very helpful to understand how the expert has worked with legal teams before in such matters. So I don't know if that sort of covered the ground, Graham. That's broadly
Yes.
what I think one needs to look at when being appointed as an expert.
Thank you. Okay, I'm going to fast forward quickly through some other questions that we have. We'll still address this, but you now, so Ken, I'll turn to you. You have your expert appointed. You've briefed your expert. You're now at discovery stage. Could you talk us through, from a legal perspective, some of the challenges for the expert that you've seen when going through discovery?
Yeah, and I'm going to keep my remarks a little bit limited here because I found myself in the middle currently of several very contested discovery disputes involving experts, both in court and in arbitral proceedings. So I'm going to keep my comments high level, and I'm sure, Graham, that you and Karthik and the rest of the panel can fill in the gaps here. I think during the discovery process, the expert has several potential roles. One role is that the side that I represent usually will be requesting discovery disclosure from the other side. And it can be invaluable to speak with our expert to understand the sorts of materials that would be useful to get so that they can formulate the most accurate and best views in their next expert report. Very often at the stage of the case where disclosure happens, it still could be relatively early, and the legal team may not be totally up to speed with all of the nuances and details, particularly of very technical issues. So working with an expert who is able to advise us on the sort of materials that would be of benefit to them and the tribunal to get during the disclosure process can be, I think, quite helpful. I think the other issue, though, that comes up quite frequently with experts in disclosure, and I'm gonna steer a bit clear of this, is how far can expert disclosure actually go? There are often questions of what is privileged. Are materials covered by the work product doctrine for those jurisdictions that have the work product doctrine? What jurisdictions are even relevant? If you have a Chinese joint venture the dispute is about, and one of the parties is French and the other party is Nigerian, and they've agreed to resolve their dispute in London, but it's governed by Swiss law. One of the counsel teams is American, another is Australian. The experts are from Dubai and Singapore. What laws do you apply when you're looking at whether communications and materials are privileged and whether there's work product protections? So these are the sorts of issues that can come up during this process. Generally, in my experience, the scope of what experts disclose rather than the scope of materials that are disclosed by the parties themselves that might be of use to experts. The scope of what experts disclose and the disclosure process is usually very narrow and quite limited and rarely is dispositive of the case. But I have seen, and I'm currently seeing, quite a bit of time and money spent on these issues. So because of that, I'm not going to say anything more, but I'll leave it to others to fill in the blanks.
I'd like to actually come in on this one, if I may, as well. It's the discovery process is a matter which is quite close to my heart. Having had some quite unbelievable experiences in this past year. So in my opinion, it's essential that experts receive the same instructions, ideally directed directly from the arbitrator, with the parties' respective solicitors having mutually agreed what the experts should be opining on. And any subsequent opinions must be based on the information that's available to both experts through a formal discovery process. Now, you would assume that this is obvious and it goes without saying, but actually on several occasions, I've been on the receiving end of reports which relied upon information that wasn't formally disclosed between the parties, and of course led to very different conclusions between the respective experts. So I would say more often than not, this was caused by the opposing expert's inexperience, and really by him accepting information informally and directly from the client. But this can lead to sections of the report being struck out, or the instructing solicitor scrambling to disclose information relied upon at a very late date. And as I mentioned, this actually happened to me earlier this year. The opposing expert, who will remain unnamed, acknowledged in his without prejudice report that he had met with the client separately on several occasions and had relied upon information that his client had passed to him during these meetings. Now, this information hadn't been formally disclosed to me, and having acknowledged that this caused an issue with the resulting conclusions and opinions in the WP report, the same expert then proceeded to do exactly the same thing in his open report. So he actually went into writing saying that he'd been provided with additional information, which he understood hadn't been formally disclosed, but he assumed in his wisdom that the arbitrator would allow the information into the proceedings at a later date, so he felt comfortable to rely upon it. So these are the kind of real experiences that we as experts do come across. And that's why it's, from our perspective, very important that we have the strong backing of a legal team that will refute these issues when they come about. And in fact, of course, a strong arbitrator who will respect the rules of natural justice, but will respect the fact that there's a discovery process in place and that both experts must share the same information. I'm going to continue I'm mindful of time, so I'm going to fast track some more of these questions that I do have as we move through the appointment of the experts. So your experts are now appointed, and we're at joint meetings. So this is before the experts have submitted the reports, but they've received their instructions and they're ready to meet the opposing experts. Karthik, if I could ask you a potentially contentious question, and then I'll turn to the legal team. What do you expect from your legal team when you're undertaking joint meetings? What level of participation, for want of a better expression, should they have? And I'll then direct the same question to some of our lawyers.
Thanks, Graham. I think this is a tough one on a public forum to answer, but I'll try my best. I think when we have good experts on both sides, this might be a helpful exercise, but equally, this can be a waste of time. And these meetings are generally done, as you said, Graham, on a without prejudice basis, meaning no statement made during these discussions can be put in as evidence against the interest of the party which made the statement. So the object of these discussions is to identify the issues between the expert and, if possible, resolve those differences. But it is not for experts to seek to settle the case in such discussions. The object is to reduce the issues which remain in contention. And to that end, may I say, it is impermissible for an expert to be instructed or for the expert to accept instructions, not to agree or differ agreeing any matters which fall within the expert's competence. And I think that is the nub of the issue. Sometimes lawyers do get involved, unfortunately, and push these agendas into the expert meetings, and that can result sometimes in some friction. Now, there are two recent English court cases that I'd like to sort of touch upon, just the statements that were made. In Saunders versus Central Manchester University Hospitals NHS Foundation Trust, the judge was critical of a 60-page joint statement that did nothing to agree and narrow the issues. As I said before, it needs to be narrowing the disagreements. It seems there had been no separate agendas with repeated questions rather than one agreed agenda. So the solicitors had failed to cooperate and had descended into a proxy war over the issues. And this happens a lot, let's be honest. This can be often the case if the process is not managed well, both by the expert and by the solicitors. There's another matter in Mayer and others versus CMS. And the judge noted, and let me just bring this up, he said, it is the expert's responsibility to agree the content of the joint memorandum. This is part of the duty to the court as independent experts and is the basis on which the court gives permission for expert evidence. While the lawyers may properly assist the experts by ensuring that they focus on the issues which the court will need to determine, neither clients nor lawyers have any role in dictating to the experts what they can or cannot agree. I didn't say this, a judge said this. So, I'm just trying to wash my hands of this. This clearly demonstrates that things may not necessarily go well with a joint statement if it is not organized properly, especially by the experts and the instructing counsel.
Okay. Over to the legal team. Glenn, any comments on how involved are you typically during joint meetings and in preparation of a joint statement?
I try to be involved as little as possible, Graham, because the joint statement should be a genuine effort by the experts to see what they can agree upon, the things they can't agree upon, and then an explanation in simple terms to the tribunal why they can't agree on that issue. Seems to me that unless the expert wants some guidance about lack of clarity in the issue, or is there a gap in instructions, or is there some mixed legal issue involved, all that's going to happen if they involve the legal team is that they said, oh, please don't say that because that's not going to help our case. And that's precisely what you can't tell the expert to do. So I tell the experts to get on with it. Yeah. I like to see the joint statement so that if I think that they've genuinely misunderstood something or they're going off the rails, I can politely share my view. But, otherwise it just seems to me that you're in danger of trespassing and putting pressure on the expert precisely as you should not be doing.
Yes, agreed.
And, and even if, and we can come on in a moment maybe about, pitfalls and mistakes that experts, and the same thing you see with factual witnesses, even if you were to prevail upon a witness to avoid saying something or to change how they were going to word something, and there's all sorts of ethical and malpractice issues involved in that. But even if you succeeded in doing that, when the experts in the witness box, the pressure's on, they're almost always going to default to the truth and what their opinion really is, or be made to look absolute fools. So, I just see it's a zero-sum game. It's just positively dangerous.
Yes. Gents, I'm mindful of the time. We have 10 minutes left, and we have a couple of questions which I'd like to address from the audience as well. Let's move on very quickly to the report itself. Phil, could you talk us through, it's a somewhat open question, but what makes a good expert report and what are some of the common pitfalls?
Okay, thank you very much. That's a question I'm often asked by experts, and I've got a list of things that, in my view, need to be ticked. First of all, there obviously needs to be satisfaction of any civil procedure requirements in the jurisdiction you are dealing with, assuming you're in a court. We've talked about independence. The report's got to be a truly independent report. Glenn's made the very important point about adhering to deadlines. That's something I would really emphasize myself. The opinion in the report must be based on the facts or assumed facts. And of course, those facts must fall within the expert's expertise. And very often, I would advise the expert to give evidence of what a body of opinion would do, in particular in a professional negligence case. These days, many reports are ordered to be in electronic format, so you've got to have the ability to produce a report in an electronic format, and obviously it needs to be provided in a format which cannot be interrogated. Now, as to a little bit more detail, it seems to me that the report should be a standalone, comprehensive, self-contained read which avoids, wherever possible, technical jargon. It should be concise, in a user-friendly format, expressed in the first person singular by the person whose opinion has been given, or who adopts as his own opinion the views of others. And it should deal with the specific matters, and only such matters, which fall within his or her field of expertise, and which, of course, the expert has been asked to address, including any specific issues in a list of issues which, more often than not these days, is ordered by both the courts and indeed the arbitral tribunal. The text should be arranged in short sentences and with numbered paragraphs and with appropriate headings. It's obviously got to be as user-friendly as possible. In my view, there should be the judicious use of appendices. Why do I say that? In my experience, material which is included in an appendix as opposed to the body of the report is less often to be read than what is in the body. So be wary of that. And matters of fact should obviously be kept separate from matters of opinion. What about the conclusions? The conclusions, in my view, should be given in the final section of the report before any appendices, and as to which you've already heard my views. And these conclusions should be accurately cross-referenced to the text, which supports any particular conclusion. Importantly, each opinion expressed in the report must, I emphasize, be the opinion of the writer, whether it was indeed formed by others or formed by the writer. In the first case, of course, the writer would be adopting the opinion of others. He's entitled to do that, but he's got to say why he does that. And it seems to me that the following should be separately identified and distinguished: facts which the writer is asked to assume, facts which the writer observed for himself, facts which others acting on behalf of the writer observed, identifying the persons concerned, opinions of others upon which the writer relies in forming his own opinion, and I think, finally, opinions of others which the writer accepts, but upon which the writer cannot comment authoritatively. So there's been a bit of a race against the clock there to express my views, but that, in summary, is what I would expect from an expert's report, And indeed, when I'm asked to advise on that particular matter, they are the points I emphasise. I don't know whether any of my fellow lawyers have anything to add or disagree with.
Well, Phil, what I might do, if I may come in here, we've got 5 minutes left. I'd like to address a question from the audience, and it's really about the professional expert, something that we touched on a little earlier. So the relevant qualifications and experience in one's area of expertise have always been a table stake for expert witnesses. We touched upon earlier that sometimes experts can fall short of their understanding of the role. I guess the question becomes, how important is expert training for those actually undertaking expert work? One of the things that the panel mentioned was that there is a requirement for your expert to be up to date, to practice in his or her field of expertise. A member of the delegation has actually asked and said, well, what about engineers who have perhaps retired 10 years ago and they're practicing as experts now? Surely they can still add real value. So in that context, what are your thoughts about expert training? Do experts need to be formally trained? Let's start off with Ken. 4 minutes, if we may.
Yeah, super quickly, I think I would say I'd split it into substance and procedure. In terms of their substantive knowledge, they certainly, I don't know if I'd say formally trained, but they need to be up to date. They need to be well aware of what is current and happening in their field. And I think the point on using someone who has not been on a construction site for 10 years is not that they would be formally disqualified from serving as an expert, but rather, if they haven't been on a construction site in 10 years, they might not know about modern practices at construction sites unless they have some other way of having that knowledge. So you must stay current and up to date with your knowledge, and that will be different depending on the area of expertise. And just very briefly, procedurally, I think, experts who are preparing to testify, this is a whole nother topic, but, it again goes back to legal culture and professional ethics. Some lawyers, an American lawyer might feel very comfortable prepping them very heavily for their testimony. An English solicitor might not want to do that at all and instead send them to some, training class and so on. But I do think that particularly for experts that this is their first or second rodeo, they haven't done this many times. There are trainings, to use that word, that you can do to help them be more confident and familiar with what's coming.
Thank you. Phil, any comments?
No, apart from saying, without mentioning any names, that there are various bodies, including bodies in the UK, which purport to train experts in the sense that they run courses for them. I'm sure that the delegates and indeed my fellow speakers are aware of the names of at least some of those organisations.
Thank you. Kartikey?
Not much to add except one thing. It's not only courses, it's not only about, prior experience. Knowledge sharing sessions like these, which give you a flavor of how procedurally it's going to work. I think these are quite beneficial. And, I always take an expert appointment to be akin to an arbitral appointment. You have so much of movement about giving first arbitrator appointments to young lawyers. So the same thing applies for experts. You have to try it. And the more you try it, the more experience you get and better at it.
Thank you. To the other panel members, apologies, I would ask you also. We are, however, 2 minutes from the end. So I think we should probably conclude the panel discussion there. I'm very grateful to our panel for taking the time out of the weekends to share their thoughts and insights into the role of an expert. And I'd also like to thank the SCL committee for organising such a comprehensive conference and allowing us all to participate. So with that, to our delegates, please do enjoy the rest of the conference. We look forward to hopefully working with you at some point in the future, and we'll call it a day there. Thank you.